Hi, I'm Betsy Urbance, Illinois Realtors Chief Legal Counsel. Joining me today will be Annalise Fierstos, Illinois Realtors Legal Hotline Attorney. In episode 5, we're discussing a few major topics under consumer protection and business practices as a heading. First, let's start by talking about the Illinois Real Estate Recovery Fund. The Recovery Fund is provided for in RELA under sections 20-85 and 2090. In the past, the Recovery Fund, which was money that came out of licensure fees that was put into a fund and made available to folks that are aggrieved by some bad acting real estate licensee, and they might have no other means of recovery. As an example, let's say a managing broker ran off with $300,000 in earnest money, and while that managing broker is sipping umbrella drinks on a beach in some remote island, he has no money in the States and no mode for recovery for that person whose money was stolen. In that case, there are these provisions, and there have been these provisions, for the consumer to be able to access funds and hopefully be made whole. However, up until now, these provisions are almost so draconian as to make it nearly impossible to get to these funds. Now, the procedure has been abbreviated so that while you would need to file suit seeking return of the funds, all you have to do is be able to prove some basic level of inability to recover in order to go after the recovery fund under the revised Real Estate License Act. The department, through the Division of Real Estate, is currently working on construction of a rule regarding the Real Estate Recovery Fund. At the moment, the proposed sections are these. There is a proposed subsection that sets the amount for recovery by an aggrieved person at $50,000 plus attorney's fees and costs of suit in connection with the conduct leading to the claim. The maximum aggregate amount of recovery out of one set of facts, including costs of suit and attorney's fees, is currently $300,000. That amount would be spread equally among co-owners. Section 20-90 in the Act, if anyone ever needs to know how to access the recovery fund, sets forth the procedure for filing a claim against the recovery fund.
In further efforts at consumer protection, the Real Estate License Act has added the practice of wholesaling under the definition of broker. Keep in mind that the definition of broker includes all sorts of activities, and those are the activities for which you need to be licensed in order to do those within the state of Illinois. Under the definition of broker, they have added specific language outlining wholesaling. I'm going to read the provision so that you understand the language. Whether for another or themselves, engages in a pattern of business of buying, selling, offering to buy or sell, marketing for sale, exchanging, or otherwise dealing in contracts, including assignable contracts for the purchase or sale of options on real estate or improvements thereon. So essentially, it's the buying and selling of contracts. In other words, you have a buyer who makes an offer on a piece of property, and they, instead of closing on that offer, turn around and sell the contract to somebody who's waiting further down the line, and they take the difference in the price. The reason they brought this under the purview of the Act, and now under the purview of IDFPR, is because the consumer needs to be protected. A lot of the parties who are the seller in these situations are not aware of the fact that their property could be sold at a higher value. So now that this is brought under the purview of the Act, anybody who's engaged in this process on 2 or more occasions during the course of the year is required to comply with all of the requirements that a normal licensee would have to comply with. For example, they need to disclose to the seller what the intent is with respect to the property. They cannot misrepresent what the value of the property is to the seller. They will be governed by IDFPR with respect to compliance with these provisions.
Just to add a little bit to what Annalise was telling you about wholesaling, this is a consumer protection provision. It brings it squarely, it brings assignable contracts as a business practice squarely under the License Act. And really, if you think about it, in a situation where a person never intends to close or take the risk of ownership, for example, in a flipping, there are legal flips where you buy it, you hold title to the property for anywhere from 7 minutes to 7 years or ad infinitum, but you've taken on responsibility for that property. The difference in the wholesaling as a business practice is you're literally putting the seller with the end buyer, which, if you think about it, is the definition of brokerage, without owing any duties to anyone. So the consumer protection idea behind putting wholesaling as a business practice into the License Act is to at least require that person to disclose the true position. I don't know that there's any way that that wholesaler could be representing anyone other than himself. So under License Act, you're prohibited from being a dual agent in a transaction where you have or will have an interest in the property. So you couldn't represent the seller. You couldn't represent the end buyer. You have to be representing yourself. And now you're under, as Annalise said, the purview of the License Act. So any money you make has to go through your sponsoring broker, and you get paid whatever you get paid per the terms of your independent contractor agreement with your sponsoring broker. But that was the thinking behind putting that wholesaling business practice into the License Act and subjecting it to consumer protection provisions. Again, as Annalise said, typically sellers are distressed in this situation and don't fully understand what's going on. And what happens when the wholesaler can't assign the contract? Where is that seller now? The seller's probably in a position where he'll have to hire a broker to put it on the market and try to sell it outright, as opposed to assigning a contract and making money on the spread for the wholesaler. Finally, as an issue under consumer protection and business practices, and as we've discussed in prior episodes, would be this concept of the guaranteed sales plan. I don't know how much guaranteed sales plans have really come into being that much, but they have gotten some attention following certain folks on reality TV programs talking about how a guaranteed sales plan might be the best thing since sliced bread. So under Illinois Real Estate Licensing Act, the provisions haven't really changed so much, but they've gotten more focus in that they are clearly set forth in their own section and then also added to the list of bad acts, which is where they were housed before. What are the requirements? In a guaranteed sales plan, the price must be established before entering the listing agreement. So the prospective listing broker must establish what the guaranteed price that that broker will buy if it doesn't sell in the time period. That has to be done before the listing is signed. All details and conditions must be fully disclosed, including the price and time periods of the guaranteed sale. The property must be marketed in the same manner as any other listing. The licensee must not purchase until the period of offering the property has ended. And finally, if any of these provisions are ignored or fail in any aspect, there's potentially up to a $25,000 fine involved for not following the provisions required in a guaranteed sales plan.